I wanted to talk about organizing your case file or your case for the judge. So, a lot of times when I meet with clients for the first time, I feel like they're all over the place in terms of telling me what has happened in the past that is causing them to ask for the result that they want. And it's hard for me to keep track of when and where things happen. What I often tell people when they retain me to hire them is that it would be really helpful if they would create a chronology that, of course, is in date order, and it can start with the most recent, or it can start with the furthest back events, but it just needs to be chronological. And I would like them to give me dates, because in the courtroom, dates are really important. A lot of times when people are giving testimony, you have to meet certain foundational requirements and let the judge know when things happen. If you can't nail it down to a certain time period, it's possible that that evidence may not come into play. The judge may not admit it. So my thought is it's always better to nail down those dates sooner rather than later. So put time frames on things, even if you don't have an exact date. If you at least have a month and year, that would be great. And details about what happened. If you could put down location, that would be great too. And this is why it's really valuable for people to keep a journal, even when nothing is happening in their case, because if something does happen at some point down the road, then they can refer back to the journal, and all those important details are in the journal. So create a chronology. And when you're drafting your motions and your pleadings for the court, there's different ways that you can organize those things. I tend to think in a linear fashion, so I often create things in chronological order. So that's why I like things chronologically. When you're drafting something for the court, just make sure it's organized in some way. If you're scattered, then I think a lot of what you're trying to say gets lost in translation. Your writing needs to be clear and concise. I want you to think back to your English classes when you were in high school or middle school, and write in active voice for the judge. So active voice means that you're saying Wendy wrote this letter instead of the letter was written by Wendy. That's passive. Active voice is more powerful for the court. So organized, active, persuasive. Not too many adjectives. Believe it or not, when you insert too many adjectives into your writing, it weakens your writing. That's my opinion. That's the way I was taught in the law school that I went to. So if you use just really strong verbs, that's enough to convey the point. And always, always be sure that all the details that you're putting in writing and all the details that you communicate in court are true and that they're accurate. If you realize that you misstated something in a motion or on the stand, you really should immediately correct it with the judge, because you don't want the judge to think that you were trying to mislead the court, because that could come back to bite you. If the judge thinks you're being dishonest, the judge may never believe you about anything again.